Hi Dr. Nadia, my name is Clement Su and I will be presenting on the issues of climate change and the compliance with emissions reduction targets. Firstly, the multilateral environmental agreements, known as MEAs, are legally binding treaties between 3 or more countries that address environmental issues. MEAs are international agreements which focus on environmental issues such as climate change, and the creation of MEAs binds the international law. MEA's aim is to protect the environment and help to address environmental problems at the national, regional, and global levels. Those legally binding agreements between countries may appear in different forms such as conventions, treaties, and protocols. Countries that have agreed to become party to these agreements by ratifications or accession. Nevertheless, if these accords are widely accepted, individual nations may still have different emissions reduction goals. Whether a nation is functioning under a monist or dualist system also affects how international law is applied to domestic law. Moreover, what is a dualist or monist legal system, and what are the imbalance between the system and difficulties that contribute to it? To start off, in international law, the monist and dualist theory are two contrasting approaches to the relationship between international and domestic law. Monist is a system in which international law automatically becomes a part of the domestic law upon ratifications of the agreement. It is where the treaties are directly enforceable in national court without the need to require additional domestic legislations. There is no need for separate legislative actions to give effect to treaty obligations. Monist posits that international law is incorporated into and superior to domestic law, creating a unified legal system in where international law governs over domestic law. States with a monist system, the international law does not need to be translated into national law. The act of ratifying an international treaty immediately incorporated that international law into national law. Therefore, the ICC statutes can be directly applied and adjudicated in national courts. On the other hand, a dualist is where the international law does not have the direct effect. The treaties require specific domestic legislation to be enacted before they have the legal force within the country. Ratified treaties require enabling legislations to translate their obligations into national law. Dualism argues for a clear separation between international and domestic law, where international law requires domestic implementations to be binding at the national level. States with a dualist system, the international law is not directly applied domestically. It must first be translated into national legislation before it can be applied by national courts. The relationship between monism and dualism are two different components but is complementary aspect of one single system. Dualism are distinct and different legal systems from monist. As in the case of Grassrand Gold Mining Co. against Rex 1905, a case related to property confiscated during the war in South Africa, Lord Averstone held that international law principles do not automatically form a part of domestic law unless incorporated by the Act of Parliament. Moreover, the international law is supreme, having different character from the state law because in international law, there is a large number of state law will involve, and international law will prevail over any dispute or conflict. Next, what are the possible legal and practical challenges of monist system? International treaties are immediately incorporated into domestic law under a monist legal system after they are ratified. While this structure facilitates the absorption of international commitments, it does not bring distinct legal and practical obstacles. Harmonizing local legislations with international obligations under multilateral agreements MEAs such as emission reductions targets will involve numerous legal and practical issues to consider. In the Kyoto Protocol, a historic treaty under the United Nations Framework Conventions on Climate Change (UNFCCC), has encountered numerous legal and practical obstacles in implementing and compliance, particularly in meeting emissions reduction targets. The first legal challenge is a lack of enforcement mechanisms. The Kyoto Protocol encounters severe problems due to lack of strong enforcement mechanisms. While the treaty established enforceable emissions reductions objectives for Annex 1 countries, it depends mainly on volunteer compliance and did not include real sanctions for non-compliance. For example, if countries fail to fulfill their targets, they were merely required to offset excess emissions in succeeding commitments periods, which was viewed as insufficient harsh. This insufficient framework permits countries like Canada to withdraw from the agreement in 2011 with no penalties, alleging financial losses. Furthermore, the treaty lacked tools to require governments to give honest reporting, which undermines its legitimacy. This flaw underlines the needs for more accountable measures and enforcement instruments in future treaties, such as the Paris Agreements, which prioritize volunteer contributions and openness above punitive penalties. This insufficient framework permits countries like Canada to withdraw from the agreement in 2011 with no penalties, alleging financial losses. Furthermore, the treaty lacked tools to require governments to give honest reporting, which undermines its legitimacy. This flaw underlines the needs for more accountable measures and enforcement instruments in future treaties, such as the Paris Agreements, which prioritize volunteer contributions and openness above punitive penalties. Next, the first practical challenges, the economic disparities. The Kyoto Protocol emphasized global economic imbalance by separating obligations between industrialized and developing countries, while the Annex 1 countries were forced to reach enforceable carbon reduction objectives. The non-Annex 1 countries were allowed to focus on economic development. This divide sparked significant debate, with many wealthy countries claiming it unfair, exempted big polluters such as China and India, despite their expanding emissions due to rapid industrializations. In contrast, developing countries frequently lack the finance and technological abilities to pursue environmental friendly policies or fully engage in systems such as the clean development mechanisms. These gaps hamper global corporations, causing disputes over equitable accountability for climate action. Now, the first recommendations is to enhance flexibility and inclusiveness. To increase Kyoto Protocol adherence, global climate commitments must be approached in a more versatile and inclusive manner. Unlike the rigid Annex 1 versus non-Annex 1 structure, a more fair system that allows countries to determine their own emissions reduction objectives based on national conditions will promote greater participations. This flexibility could be consistent with the Paris Agreement structures of nationally determined contributions (NDCs), which accommodates differing capabilities and encourage more active participations from both developed and developing countries. Flexibility could improve global collaborations and ensure all nations contribute equally based on the economic and technological capabilities. Now, the next issue for Monists is MEA commitments, including the treaties such as Kyoto Protocol, Paris Agreement, and Convention on Biological Diversity, frequently contain broad and flexible language to account for members' nations' various legal systems, economic situation, and developmental demands. The broad language of MEAs leads to ambiguity in interpretations. When applied to a country-specific legal or environmental context, broad terminology of the emissions reductions of MEAs may cause complications. The second legal challenge is ambiguity in language. Multilateral environmental agreements (MEAs) frequently use broad and vague wording to accommodate varied national contexts and promote universal involvement. Terms such as endeavor to achieve, appropriate measures, and as far as possible are flexible but lack specificity. This ambiguity can lead to differing interpretations and implementations among parties, impeding compliance and enforcement. For example, the Paris Agreement's pledge to keep global warming well below 2 degrees Celsius lack comprehensive sector-specific rules, enabling countries to determine how to reach this goal. Such ambiguity creates enforcement gaps, particularly when disagreements arise over what constitutes effective actions. Furthermore, countries with inadequate institutional structures may fail to turn these wide commitments into concrete local policy. The second practical challenge is the lack of resources. Multilateral environmental agreements (MEAs) are frequently hampered by resources limits, particularly in developing nations. Financial, technological, and human resources are crucial for fulfilling pledges under agreements such as the Kyoto Protocol and the Paris Agreement. However, many countries lack the funds required to make investment in sustainable technology or successfully enforce environmental legislations. Furthermore, a lack of access to technological skills and infrastructure hinders the ability to monitor, report, and verify progress on pledges. This discrepancy affects MEA's global effectiveness, and poorer countries struggle to perform their responsibility in addressing climate change. Addressing these gaps requires strengthening financial mechanisms such as the Green Climate Fund and fostering technological transfer. In the case of Agenda Foundation against Netherlands 2009, the Netherlands, which has a monist system, demonstrated that the Dutch court intervened to push the government to take stronger climate actions because the broad premises under the Paris Agreements do not provide sufficient guidance on the manner of enforcement. To close the gaps between the Paris Agreements and national law, it is necessary to interpret it in combination with the Dutch law. Now, the second recommendation is a strengthening interpretive guidelines. To address ambiguity, MEAs should use more explicit language and monitoring system to promote clarity and accountability. It is essential to strengthen interpretive guidelines. This can be accomplished by forming expert panels or advisory organizations to provide uniform and reliable explanations of ambiguous or unclear rules. Next, what are the possible legal and practical challenges of dualist system? In dualist system, foreign treaties must be transferred into domestic law through a separate legislative process after ratifications before being implemented within the country. This often causes legislative delays. The first legal challenges. This process will almost certainly result in legislative delays because changing the draft, debating and adopting the bill can take years. Foreign treaties cannot be immediately incorporated into a country's legal system. They must be converted into national law through a proper legislative procedures. This frequently entails writing, debating, and passing new laws or amending old ones. This process can be long-consuming and is influenced by political considerations such as legislative time and political willingness. Delays in legislative procedures can cause delays in implementations of international accords, resulting in non-compliance with treaty responsibilities. Even after treaties have been adopted into national law, changes in executing may still occur. Different interpretations of the treaty's terms by national courts or government bodies can weaken the treaty's implementation's effectiveness. Now, the first practical challenges. Political resistance to international treaty implementations is frequently a sustainable practical obstacles in dualist legal system. Political actors such as legislature, industry groups, and interest groups may oppose integrating international commitments into domestic legislations if they believe these accords are detrimental to national interests or economic sectors. For example, in environmental treaties, industries such as fossil fuel and agriculture may fight rules that limit emissions or impose new standards. The Kyoto Protocol itself was opposed by both industrialized and developing countries. Some countries, including the United States, withdrew from the protocol citing economic concerns and the unequal weight placed on developed countries. This form of political pushbacks has made it difficult for nations with dualist system to pass the domestic law required to certify Kyoto emissions reductions commitments. The first recommendations. To avoid legislative delays in dualist system, governments should form specialized environmental committees that provide professional rationale and guidance on the execution of international treaties. These committees could provide expert advice, develop legislations, and communicate with other ministries to ensure a smooth process for implementing international commitments into national law. That could be helpful in communicating the environmental and economic benefits of treaty implementations. In conclusion, monist systems integrate international treaties automatically. However, enforcement is difficult owing to ambiguity and resources constraints. While a dualist system necessitates legislative change, resulting in delays, and therefore clear standards, increased coordinations, and specialized institutions can close these gaps, guaranteed effective compliance with international commitments across both systems. Thank you, Dr. Nadia.